Thank you. Once again, I'd like to say good morning to everyone on this session. Special good morning to our distinguished ladies and gentlemen. I must say it's a privilege and honor to have you as our guest this morning. And on behalf of the entire Meristem team, we want to say you're welcome, specially welcome, to another edition of our Wealth Preservation series with this special theme, with this special conversation titled Joint Ownership and Estate Planning, the Perks and the Pitfalls. Joint Ownership and Estate Planning, the Perks and the Pitfalls. That's the theme for today's conversation. And I must add that this event is being put together by Meristem Trustees Limited, a subsidiary of the Meristem Securities Group. For us to start this conversation, there's a famous quote by a wise man, which I often like to get started with. And he said, the key is never to predict the future. Yes, the key is never to predict the future, but it is to prepare for it. It is to ensure that your loved ones, my loved ones, they are protected and they are secure in our absence. And so this morning, to do justice to this subject of joint ownership and estate planning, we have in our midst a panel of esteemed resource persons who have been put together with vast experience in wealth management, estate and succession planning. And so today we have Mrs. Olushola Adegbomire and Mr. Olamide Oshikoya. These are vast and experienced persons that we have in-house who will be talking to us on these important subjects of joint ownership and estate planning. And so I want to urge you to be steadfast, rooted on your seats, because the next hour promises to be worthwhile. It promises to be decisive, and certainly is going to be life-changing. And I must admonish every one of us, you have an opportunity to ask all of the questions. Make use of the Q&A tab below, and I can assure you that all questions will be dealt with. And so for us to begin the conversation this morning, we'll get started with Mr. Olamide Oshikoya. Yes, we'll get started with Mr. Olamide Oshikoya, but allow me to introduce him briefly. So I'm going to share my screen as I give you a slight introduction on who Mr. Olamide Oshikoya is. I don't know if you can see my screen. Can you just please confirm if you can see my screen?
Yes, we can.
Thank you. Thank you. So this morning, who is Mr. Olamide Oshikoya? I must add that Olamide Oshikoya is a senior associate with one of the country's foremost law firm, Banwo and Ighodalo. He holds an LLB in law and also an LLM from the University of Manchester. Mr. Olamide currently leads the real estate team at Banwo and Ighodalo. Over the years, he's gathered significant experience and expertise in real estate infrastructure, project finance, corporate law, commercial law, and immigration law. Over the years, Mr. Olamide has garnered numerous local and foreign clients. He's been involved in several flagship projects, some of which, and a lot of them, are quite the first in our Nigerian environment. He's a member of the Real Estate Lawyers Association of Nigeria, and I must add that Mr. Olamide is an avid lover of football. And certainly tonight, I'm sure he'll be watching the game between Nigeria and Ghana. So to get started this morning, he will be setting the sail. He will be laying the foundations for today's conversation on joint ownership and estate planning. Mr. Olamide, the floor is yours. Thank you.
Thank you very much, and good morning, everyone. Thank you for your time in attending today. I'll just quickly share my screen. Okay. Can you all see my screen?
Yes, we can. We can. But I'd like you to just please put it on the slide mode.
One second.
Okay. I think it's okay.
It's okay. Can you see it now?
Yes, we can.
Okay, so this morning I will be taking us through, well, the topic before this morning is joint ownership and estate planning, effects and pitfalls. And I will be taking us through the joint ownership bits of the discussion, just to lay a foundation for the next speaker who will be taking us through estate planning in detail. To that extent, we'll just be talking quickly around this context. We'll look at the introduction. We'll look at some common methods of ownership or co-ownership of assets. We'll look at ways by which co-ownership of assets can be created. We'll look at unique features of joint ownership, legal implication of the two key co-ownership arrangements, and then determination of joint ownership. So I start this morning by saying that assets generally can be held individually or in conjunction with other persons. And when I own an asset in my name, Olabide Shikoya, all the documentation is in my name, it's a lot easier to deal with, right? And I essentially can pass on that assets to my beneficiaries without any complication. But things could potentially be more complicated where there are two or more persons that have interest in that same asset. And I'm sure that at the end of this presentation, you will be able to understand what I'm saying in greater details. Now, like I said earlier on, it's possible, or the easiest way is to own assets individually or by yourself, as one person, individually or as a corporate entity, for your exclusive use or enjoyment. Right. On the other side of the divide is what we call co-ownership. And under that arrangement, there are potentially two possibilities. I mean, outside of Nigerian law, there are other arrangements that are possible. But for the purpose of this discussion, since we are in Nigeria, the two most common co-ownership arrangements in Nigeria are essentially joint tenancy and tenancy in common. And when I say joint, and when I use the word tenancy, sometimes I will use it interchangeably with ownership. And when I also say assets, I will also use it interchangeably with property. So I just go straight into it. Joint tenancy is created where a property is granted to two or more persons without words of severance. And I say without words of severance. I've underlined and bold that because that's key. So that the co-owners of that property are united in every respect. And when I say united, I will speak about that in greater details in subsequent slides. But for the purpose of this slide, I should just say that joint ownership of property is created where two or more persons hold assets without words of severance, and they are united in every respect. And I've put an example here. If a testator says in his will, for example, that I give my property as ABC Street to my sons jointly, that word jointly is a word that essentially binds all the co-owners together. And essentially it means that the guys who have been given that property will own the property jointly. On the other hand, there is the possibility of having a property as tenants in common. And this is essentially where specific words of severance is used to grant access to two or more persons. And when I say specific words of severance, you will see it in the example that I've given here. A testator, again, same example, the testator can say, I give my property situated at number 2 ABC Street to my sons to be divided equally. The word divided in that sentence shows that there is specific reference to, there's an intention for the co-owners to have separate interest in that particular property. And as we go along, you will see how this will play out in real life. Now, this slide is talking about what are the circumstances in which joint ownership of property can be created. So for example, it's possible that my dad or my mom can give a property to myself and my siblings under their will or under other arrangements. And if that happens, then we can be said to be co-owners of that property. I could also decide to acquire a property with my wife, for example. And if that happens, I will be deemed to be co-owning that property with my wife. Again, for whatever reason, I may also decide to come together with my friends or my cousins or some other family members and decide to buy a property together. Again, if that happens, there's some co-ownership arrangements between us. And what this means is that basically I can own a property with my spouse, as in the example I gave, with my siblings, if, for example, our parents like to give us property jointly, with my friends, with my business partners, with my family members, or anyone else, really. What kind of assets can be owned jointly? Real property, shares in companies, monies in bank, and other kinds of securities, or any other kind of assets you can think about, but these are the common ones. Now, the question is, can joint ownership be implied? If the asset is held individually or singly by just me, the answer will be no. Joint ownership cannot be implied. But if the asset is owned by two or more persons, then joint ownership can be implied. And I say joint ownership in this case, as opposed to, and I mean joint tenancy, as opposed to ownership in common. So, for example, if an asset is given to two or more people and it's not clear whether they jointly own it or whether they own it as tenants in common, the law will presume that they are joint tenants. And as you will see in subsequent slides, you see that they are separate. This potentially provides separate incidences at the end of the day. Now, for a joint tenancy to be implied, there must be four basic unities. Remember, in the previous slides, I had mentioned that the co-owners must be united in all respects. I said that they must be united in all respects. So these unities, there are four of them. And essentially the four of them must be in place for a joint tenancy to be implied. So I go back to the slide around the four unities. Now, unity of possession is what I'll start with. Unity of possession essentially means that the co-owners, they own the entirety of the assets. They own the whole of the assets, and none of them can lay claim to a specific portion or a particular portion of the property. What this means is that none of the parties or none of the co-owners can sue the other party for trespass. Neither can none of the parties deprive the other member from the use of that property, except, of course, one of the parties is trying to exclude the other from the use of that property because they own it jointly. So if that unity of possession is present, then along with all these other unities, then the joint tenancy will be applied. Secondly, and closely connected to that, is the fact that unity of interest, in that the interest of the co-owners is essentially identical and is non-separable. Their interest in the property is such that they all own the property in common and their interest is identical. You can't say this one belongs to another person whilst this one belongs to another co-owner. They essentially own it together. Unity of title means that the joint owners obtain their title from the same grantor or from the same person. And I will give an example along this after I talk about time. The last one is unity of time. Again, the grant must have been made to all the co-owners at the same time. If for whatever reason, one of them gets after any or all of the co-owners have gotten, then it becomes a tenancy in common rather than a joint tenancy. And I will just give a quick scenario, right, to paint this point. Now, if my dad, for example, gives myself and two other siblings of mine, let's say we are Mr. ABC, title to his property at number 2 ABC Street. right? And it says that this property will be vested in us in 2025, right? And it gives to us absolutely in our lifetime and to our heirs or to our children, for example, afterwards. Now, as between myself and my siblings, we will be deemed to be joint tenants in the sense that, let's go to our 4 unities. We are going to be using it separately, so long as there isn't any words of severance in that grant clause. And I'm talking about the grant clause I had shown when I was talking about joint tenants. So let's apply all these unities, for example, and let's start with issue of time. At the point when he was giving it 3 of us, he gave us at the same time, and so would have ticked the box of unity of time, right? Again, let's look at the unity of title. Because it's the same, our father that is giving the 3 of us is giving us the property together, then, and we are deriving our title from the same person. But, and to that extent, we would have satisfied this condition as well. Now, let's talk about possession. Because we jointly own the property, we jointly have possession, and we jointly have a right to use the property together, we would also have ticked the box of unity of possession. And interest, to the extent that our interests are identical, would have ticked this box as well. Now, let's assume that before the 2025, something happens to any of my siblings, right? And that sibling has a child, right? And which means that essentially that person's child will take the place of the deceased sibling. As between the 2 of us, or the 2 other siblings that are left, Mr. A and B, for example, they will be joint tenants because all the 4 elements that we identified will still be present for the 2 owners. But as between the 2 joint tenants, the 2 siblings, and their nephew or niece, as the case may be, being the child of the 3rd deceased sibling, they will be tenants in common because, for example, they won't be deriving their title from the same person. Whilst the 2 co-owners, the 2 children of the father who is given the property, got their title from their father, their nephew is getting his own title from his own deceased father. So to that extent, there's no unity of title, and as it relates to that last person, that nephew, and the other co-owners, they will essentially be tenants in common. But as between the 2 surviving siblings, they will be joint tenants. Now, the 2, whether an arrangement is a joint tenancy or tenancy in common, they have 2 separate legal implications. For joint tenants, if anything happens to any of the co-owners, then that deceased co-owner's rights is essentially extinguished, and the surviving owners of the property would essentially have absolute ownership or absolute title to that property, and they essentially can apply it for their own use. And that trend will continue until you get to the last surviving person, who then takes the property absolutely and can then pass that property on to their beneficiary. In other words, the rule of survivorship essentially applies when the arrangement is a joint tenancy. On the other hand, if the tenancy is a tenancy in common, and if one of the co-owners die, then the rule of survivorship does not apply, and that asset, essentially that portion of the assets belonging to the deceased owner, essentially goes to their beneficiary. Remember, when we're defining tenancy in common, we said that the intention of the parties is that each person should have their separate portion within the larger property, so that share that belongs to that tenant who dies goes to their beneficiary. Now, I can imagine that everyone will want to be in a position where there are tenants in common. So, for example, you have put money together with your friends to essentially acquire a parcel of land, right? I can imagine that everyone wants to be in a situation where you will want your share of that property to go to your children if anything happens to you, as opposed to going to the surviving owners of the property who are alive at the time you're passing. So to that extent, I would imagine that you will want to, a joint tenant will want to terminate the joint tenant so that tenancy can become tenancy in common. And so that leads me to my next slide, which talks about how to determine joint tenancy. Because essentially, if any of the 4 unities is missing, then automatically that's converted to a tenancy in common. And if a tenancy in common arrangement is in place, then that disease share of the property essentially goes to his estate. So the question this morning is, how do you essentially determine a joint tenancy so that that property in question can essentially form part of your own estate if anything happens to you? One way is to partition the joint assets. The scenario I painted around the land, if you buy land with your friends, you can potentially partition the land so that each person owns their share of the land so that everybody can pass it on to their beneficiary if anything happens to them. Again, if you sell the joint assets, of course, there isn't anything binding parties together. Everybody collects their share of the proceeds and they all walk away. Now, again, it's possible for one of the co-tenants to also acquire a larger interest in the property in question, and that automatically converts the tenancy to tenancy in common. Remember, we talked about the unity of interest in the sense that their interest is identical. Once one person acquires a larger portion of the assets in question, there is no longer unity of interest, and that automatically converts the tenancy to tenancy in common as opposed to joint tenancy. Where any of the tenants alienates or assigns an interest in the asset, joint tenancy in common, so that the assets can essentially pass to your beneficiaries at the time of as soon as you pass. Because if the joint tenancy is maintained, then if anything happens to one of the joint tenants, then the property essentially goes to the surviving co-owners. At this point, I will stop at this point and I will hand over to Mr. Adegumire to take us through the estate planning. Thank you for listening, and I guess you can put your questions in the chat box. Thank you.
Thank you so much. Thank you, Mr. Olamide Ushikoya. That was quite insightful. I could hear a lot of legal terms like tenancy, and I was beginning to imagine, is it because I stay in a rented apartment? Could you be referring to, and it's just I and my family, and I don't have any family staying with me? Could that be what you're referring to as a joint tenant and the likes? But I know during the question and answer section, you will provide further insight into those definitions, into those legal terms, right? For those of us who joined late, the discussion for today is joint ownership and estate planning, the perks and pitfalls. For a lot of us, we usually don't give thoughts into going into business. I've seen a lot of persons who have gone into business, partnerships, couples who have purchased assets together, bought a house together, and down the road, sometimes a few challenges here and there, we usually do not give thoughts to these things. And that is the essence of this conversation today, for us to understand what it is about joint ownership. What are the advantages, especially when we have to plan for our estate? What are the pitfalls as well? So Mr. Olamide has laid the foundation for us. And quickly, we'll be having the next panelist, no other person than Mrs. Olushola Adebomire, a woman with outstanding personality and vast experience. I'm just going to share her profile and introduce her briefly before she comes up. Thank you. Just a second so I can put up my screen. Great. So today we have briefly Mrs. Olushola Adebomire, who will be speaking to us also on this important conversation of joint ownership and estate planning. I find her profile quite intimidating. She's a legal practitioner with over 34 years experience, a partner in the law firm Shola Ajijola and Co. 34 years practice in law. I wouldn't say how old I am, but I am scared, man. She obtained a bachelor's law degree from the University of Ife in 1984, a master's from the University of Lagos in 1987, called to the Nigerian bar in 1985. Mrs. Adegbomire, she's an estate practitioner and a trustee of the Association of Succession Trust and Estate Planning Practitioners in Nigeria. She's also a fellow and chartered arbitrator of the Chartered Institute of Arbitrators, United Kingdom Nigerian branch, an approved tutor and assessor of the institute, where she's approved and trained a lot of arbitrators. She trained in arbitration and mediation. And I must add, she's also currently the first chairman of the Nigerian branch of Chartered Institute of Arbitration. She's also an accredited member of the Center for Effective Dispute Resolution, a member of the panel of neutrals of the Lagos Multi-Door Court, where she arbitrates and mediates extensively. Over the years, her practice has been in estate planning, where she's been involved in a lot of negotiations, mediations, and various alternative dispute resolution processes. Mrs. Olushola Adegbomire, it's a privilege and honor to have you here this morning. And the floor is yours to educate us more and enlighten us on the perks and pitfalls in joint ownership and estate planning. Thank you, ma'am.
Thank you very much. Thank you. That was a long profile. Thank you very much. Please, would you share my screen?
Yes, I'm going to share your slides briefly, please. Yes.
My slides have been, let me first say, my slides have been very well touched up for me. It's one of those things I don't know how to do, but I'm learning. So if you had gotten my slides, oh, I'm not audible. Can you hear me? Please let me know if you can hear me.
Yes, we can, but maybe you might want to speak louder into your microphone.
Okay, I'll do that. Can you hear me better now?
Yes, it's quite improved. It's improved.
Okay,
yes.
Thank you. So I said I'm confessing that I didn't jazz up these slides like this, you know, the bells and whistles on the slides are not from me. So for putting all the bells and whistles on my slides, let me say thank you to you. So we go straight. I just have about 15 minutes, so I want to use it very well. So first of all, why do we have joint ownership? Mr. Olamide, Mr. Shikoya has already talked about it. You know, he's talked about what joint ownership is. So there's no need to go into that. I will just start with what is estate planning. He's already explained very well what joint ownership is, how it arises, the different examples of what joint ownership is. And now we're talking about joint ownership and estate planning. So I'll go straight into estate planning. And so what is estate planning? Most of us know that estate planning is just as the name suggests, planning and estate. But many of us sometimes, for those of us who are familiar with estate planning, we assume that estate planning is for afterwards, you know, writing wills and maybe trusts. But estate planning, I tell people, is not only for then, which is the after. You know, I have a friend who has something called here and after. So I take it from there that estate planning is not only for after, it is also for here. So when a person is alive, one must plan one's estate well as well, you know, and there are many tools used to plan estates. So you can have an elderly person who could give a power of attorney to a younger child or to a friend, you know, so that that elderly person does not have to keep an eye on the stocks and do this and do that. A husband could give his wife power in his lifetime to manage his properties. He could give a power of attorney to his wife to manage his properties. It may be that he travels a lot and he needs somebody to take care of his estate while he's not around. And also, and this is for husbands and wives, even when you are both alive, it is very helpful to have an estate properly planned. And what I mean by that is that sometimes, and it has happened, that A man is very rich, but his estate is all in his name. There's no plan for anybody else to be a part of the estate. And then he falls ill, very ill. And then they have to start looking for money, borrowing money sometimes to treat him, borrowing money to save his life, when they could easily have done that with his own money if his estate had been well planned. So it's not only for here, it's also for, it's not only for after, it's also for here. So in estate planning, a person will need to consider the assets to be managed, the persons to manage the assets, and the different tools for managing the assets. So those are three key things you need to think about when you're thinking of estate planning. What are the things you want to manage? And it could be houses, it could be bank accounts, it could be shares, it could be jewelry, it could be cars. There are many things that, we don't really think about we have to manage, but they are all things we have to manage. For a lot of women, jewelry is a major thing. I know women who keep their jewelry in banks. They have that much jewelry. In fact, I knew somebody who kept her jewelry in a bank abroad. It was that weighty. There's artwork. Mr. Oshikoya talked about that as well. So there are many things. So what are the things you want to manage, you want to plan about? Then who are the people you want to work with in your planning? Who are the people you are going to use? It could be your wife, it could be your husband, and it could be companies like Mary Stem. So people like Mary Stem are also involved in helping people to plan their estates, in running trusts for them, even in writing their wills, even though that's one Mary Stem, but they're quite involved in helping people to plan their estates. And then what are the different tools that you can use? So in planning, who are the people you are planning for? Who are the people you are planning for? What are you planning about? And what are the tools you want to use to plan? What are the tools you want to use to plan? And there are many different estate planning tools. The most common of all is wills, but there are many other tools apart from wills. So now we know what is estate planning. Let us go into joint ownership and estate planning. Why do we want to have joint ownership? And Mr. Oshikoya has talked about some of the reasons why we want to have estate plan, we want to have joint ownership. Because of course, number one is to avoid the stress of probate for at least one person. Because if a husband and wife owned property together, then it means that if the husband dies, the wife does not have to worry about probate on that property. Of course, I say it only saves the stress on one person, because when the wife dies, they would eventually have to do probate, except if, and then there's that possibility, once one person goes and the other is left, the other can then replan that particular asset. So if it's a house, for example, the husband and wife are joint owners. When the husband dies, it goes straight to the wife, who is the surviving party. Mr. Shikoya has explained all that very well. But then when it then goes to the wife then still has the opportunity while she's alive to replan that particular estate. The wife can then decide to gift it to a child, to put it in a trust. There's so many things that can then be done, or even to sell. The wife can sell and put the money into something else. So when a husband and wife do not have, and I use extra spouses, well, I don't know any other word to use, but when they don't have anything on the side, it is very helpful. But when there are extra spouses, late spouses, somebody steps and all those kind of things, then one has to be careful, because that can be a disadvantage. It's a disadvantage if you have one wife has died, you work with one wife, another wife comes in, then what about the children of the first wife? And that's why I said it can be a disadvantage when there are spouses and they did not really plan to disinherit the children or the heirs of the party who dies first. I think I've described that in another place. And then, of course, why joint ownership? Because the joint owners, they share responsibilities together. So you know that it's not only your responsibility to take care of whatever asset it is, it becomes the responsibility of two. Of course, the gain too is the gain of two, but when something is shared, It makes life easier for everybody. So that is why joint ownership. And Mr. Shkra gave some other examples. Now, estate planning for jointly owned assets. Estate planning for jointly owned assets. Good. Now, there are several things that we have to consider when we're deciding to own a property jointly. And of course, please note that when we talk about jointly owned assets, we're not only talking about houses and landed property. Jointly owned assets also include things like bank accounts. So you have to understand that bank accounts can be jointly owned or severally owned. And I always quickly advise my clients that there's a difference between a joint account, a joint bank account, and a bank account where the other person is a co-signatory but not a joint owner. So when at the end of this, if you think you have a joint account with a child or with a parent, please go back to the bank and confirm that it is a joint account and not just an account that was set up in your name and then you thought, oh, I want my wife to be a signatory. So you get new forms and you make her a signatory. God forbid, but if anything happens, if it's a joint account, she just continues to run the account because the law of survivorship kicks in. But if it's an account opened in your name and you made her a signatory to that account, then in that kind of instance, once the party dies, the other party does not automatically become a signatory and continues to act. That account ends. The co-signatory does not continue to run the account because the co-signatory is not a joint owner of the account. So I wanted to put that in so that you can go back and confirm, do we have a joint account or was it an account I opened in my name many years ago and made my wife a signatory? And since then, she's always been signing, so I can't even remember what it is. Now, please check on that. So things to consider. Consider the relationship between parties and heirs to those parties, very important. Consider the nature of the business because the asset could also be a business. Consider the structure of the family where it's being owned. And I will explain all these ones to you when I'm talking about all these things to be considered. Next slide, please. I want to try and finish everything I have to share. So consider all those things. Now, it's always important when considering buying into a joint estate. Remember that the right of survivorship is very, very real. I've seen cases where this has been a very big problem. I've seen friendships destroyed because they did not consider how real the right of survivorship is. I know two friends, they bought a property together in our Papa GRA. Huge property, lovely place. And they both built two almost mansions on the property. But they bought it jointly many, many years ago. But both of them are dead now. And then having both died, one died first. And then when that one died, the children of the one that died wanted their share of the property. The man, it was clear, the man said, well, this property belongs to me. You have to be careful who you buy with. Another person might say, no problem, take your other half. But I'm sure he had gotten a lawyer who had advised him that you are now the owner of the whole property. I mean, that is shocking, but that is real. And that is what survivorship, right of survivorship is about. And I gave an example, if Mr. Ada and Mr. Ojo both buy a property jointly and develop it together with two duplexes, and Mr. Ada predeceases Mr. Ojo, the two duplexes will end up belonging to Mr. Ojo to the exclusion of the children of Mr. Ada. That is the reality of survivorship. And so when planning for joint assets, it's very important. When even buying jointly, be careful about buying jointly, especially when it's friends. Even for some husbands and wives, I knew a couple who, the man said he didn't want to buy jointly because he knows his wife. His wife is so close to her brothers, and that if anything happens to him, she will probably give the property to her brothers before giving it to her children. So there are many things one has to consider because a property becomes the sole property of the surviving joint owner on the death of the owner. So the time to plan for a joint asset is not after one party has died. There's nothing to plan anymore. The time to plan for a joint asset is when the two owners are alive. Because when the two owners are alive, okay, we bought it together for one reason or the other. I know two friends, they are my friends and they're friends of each other. They bought a property on the island, somewhere in Victoria Island, and they bought it together because that particular property could not even be partitioned. I think the person who was selling had just bought it from Lagos State and they didn't allow partitioning, they didn't allow this. So of course, as soon as it was possible, I advised them, partition this thing and let everybody have their own part. So while parties are still alive, a jointly owned asset can be partitioned. Whatever asset it is, property, account, whatever, can be partitioned. So the time for planning for a joint asset is when the joint owners are alive. Mr. Oshuko has made it clear the difference between, for example, a joint property or tenancy in common. When it's tenancy in common, it's already partitioned. So there's not that much of a problem. But when it is a joint tenancy, there is a problem. And so the best time to deal with it is when the owners are still alive. Again, and this we can't say too much, that when the owners of the property are alive, there's something that can be done. Once they pass away and there's no plan, it becomes the one person owns it. And I said it earlier as well, if two people have a joint account, the money in the account automatically becomes that of the survivor when the other passes away without need for probate. That is an advantage. It has its own advantage. Please put it on the next slide. It has an advantage because, of course, it means that you don't have to pay for probate. And of course, in Lagos State, for example, probate fees is 10%. So if husband and wife have, let's say, 100 million in a bank account in their name, if it had been in the name of the husband only, on that 100%, on that 100 million, when the husband dies, they would have to pay 10% to Lagos State, which is 10 million. Of course, that's where Lagos State makes money. So we don't want to say they shouldn't make money to run the state. But we also have to think of how we can reduce all those fees so that the heirs can get something reasonable. So in that case, a joint account, which is also a joint asset, is very good for husband and wife. If they're just one couple, the husband doesn't have a problem that, oh, I want other people to share in the money. If the man wrote a will and it was not a joint account, you can say, I want 10 million to be given to the church. I want 10 million to be given to this child and that child. Even if the man writes a will and gives all those things out in his will, the law of survivorship makes the money in that particular account that of the wife. And it doesn't matter what he writes in the will. It's not going to change the law of survivorship. So note that there's a difference between a joint account and an account where you are just a signatory. There's a difference. So continuing on joint ownerships of assets in the family, it is better to consider holding assets in common. It is better to consider holding assets in common and jointly, depending on the situation of the relationship, especially where there are children involved. Next slide, please. Especially where there are stepchildren involved, it's much better to have a separate, to have it held in common instead of joint ownership. Why? I'll give an example. I'll give that example here. When you have stepchildren and so on, there is a problem that arises. And when there are more than one children of this, or the same parent, there's a problem. So imagine if, even before this example, I'll give another example. I think.
Okay. Mrs. Olushola, you're breaking up. I guess your network. We can't hear you. Mrs. Olushola, can you hear me? We can't hear you. Okay, let's just give Mrs. Olushola some minutes. I'm sure she's having some network challenges. We've lost Mrs. Olushola, but I'm sure she will join in again. So please, let's exercise some minutes of patience. Conversation is becoming very interesting. Quite a lot of learning points.
Okay, sorry.
Okay, we can hear you now. We can hear you now.
So, okay, thank you. So, I think you skipped one slide, the one where I was talking about Mr. A and Mrs. A getting married on joint ownership of assets in the family. That one, I said if Mr. A, and I was giving an example. So if Mr. A and Mrs. A get married as youngsters, and this one was something that happened in a case that we dealt with, and it was very sad. Mr. A and Mrs. A, they got married as youngsters. Mrs. A got a windfall from her business, and she bought a property jointly in the name of herself and Mr. A. And they were very much in love. He did not want, she didn't consider, it belongs to both of us. So there's no need to have it jointly and severally or have it in common. Oh, we just own it together. And they then both owned them. They both had 2 children. Unfortunately, Mrs. A died young in her 40s. And Mr. A remarried, who I will call Mrs. A2. Mr. A and Mrs. A2 had 3 children. And then Mr. A in his will, because the property now belonged to Mr. A A in his will passed the property to the children of Mrs. A2, who he considered they were young and they needed money for their education. Now, of course, the children of Mrs. A kicked against it. And that was how the case ended up in court, because they felt that this property, it was our mother's sweat and blood. How can you now give the property to the children of your second wife? We're not saying you don't have a right to marry, but you completely gave the property to her children. But the position of the law is that that property belongs to Mr. A, and Mr. A can do whatever he likes with it. And so, after I've spoken about these things, I've had women come to me and say, please, what can I do? The property is in the name of myself and my husband. Of course, it would even take the 2 of you together to change anything. But, those are the things that you need to consider when you're looking at holding assets jointly, because nobody knows tomorrow. And so we need to look at all those things. Joint ownership, of course, can be a good thing when it's just husband, wife, and children. It avoids probate. But at the same time, it has another problem. And I remember Mr. Shukoya talked about maybe siblings owning a property together. Now, siblings can own a property together also from joint ownership, but there could be a problem. So imagine if 3 siblings, Ada, Kemi, and Abdul, for example, jointly own a property gifted to them by their father, and Mr. Shukoya had given such an example. They all own it together, and they are all in it together. Somebody described joint tenancy as you own nothing, but you're a part of a whole. You own nothing on your own, but you're a part of a whole. So on your own, you cannot do anything with that property because you and somebody else own it together. So a property is gifted to them jointly. And then one person needs money. And I've seen that quite often in this business of estates. You have a family of 4 or 5, and you have 2, 3 people that are doing very well, and you have another, maybe 2, 3 again, that are not doing very well. In fact, maybe one doing very poorly. There was an estate like that we handled. It was a joint estate, and everybody needed to agree. It was so bad, one person needed the property to be sold desperately, because at that time, she was even working as a house help. Another person in the family was an engineer. The disparity was so much. One said, if I just get 1 million, it would change my life. The other said, if we don't get, I can't remember how much she was asking for this property, we are not going to sell. So sometimes some parents do it so as to rope the children into one forced relationship, but sometimes it just leads to more problems. So it is sometimes better to create a situation where the property can be sold easily under certain circumstances. And so those are the problems that we find with joint assets, the advantages, you can avoid probate, you can all stand as one, you can share responsibilities together. But I think that it has a lot of problems, problems. Friends fall out. Friends who are best friends, when they buy property, they fall out. And one is no more looking out for the needs or for the family of the other. When they start the business together, and when they say, oh, don't worry, you trust me, I will look after your children if anything happens, but they fall out. And I'm rounding up now, and that's the end. They fall out, and the end, the center cannot hold anymore. We really need to think very well about having joint ownership. Thank you very much.
Thank you so much, Mrs. Adigbomire. Thank you so much. This has been a very interesting conversation, and I am most certain that our audience, distinguished audience this morning, have learned quite a lot. I want to state that if we have questions to ask from all that we have heard this morning, kindly put your questions on the questions and answers tab. Make use of that tab to drop your questions, and I can assure you, with the experience we have here today, all of those questions will be answered. So, Mr. Lamide, Mrs. Adigbomire, we are grateful for this. So we'll go into the questions. For me personally, I've learned quite a lot this morning, that there's a difference between a joint account and just being a joint signatory. I have an account with my wife, which my wife is just a signatory to. So apparently I thought it was a joint account, but from this morning, I've learned it's not. It's just a joint signatory to that account. So there are quite a lot of questions which we'll be asking this morning. But particularly for me, I think this would go to Mr. Oshikoya. I had this very good friend a couple of years ago. We're still very good friends. The father had two brothers, three of them. They were into this partnership, united family, bought a very big land, vast land, somewhere in Delta State. In fact, each of them built their house in that land, each of them a duplex in that land. They were into business together at the time when the rubber business was booming. But sadly, one of the brothers died in a very, we don't know what really happened. And that began a steep decline in the family. One of the brothers died. The other two brothers somehow couldn't manage the business. The wife of the deceased took them to court, alleged that finances and resources were being mismanaged. She claimed she was being ostracized, and it was a terrible situation. And that was the end of the unity in that family. Obviously, that's a case of joint ownership, I guess. For the deceased, or for the three of them, what could they have done better? What legal framework? Is it that it was just a joint tenancy that they did? What could they have done better to forestall what transpired at the death of one of them? Thank you.
Okay, thank you very much for that question. I think Mr. Adigbomire sort of touched on that kind of scenario. And I also sort of mentioned it that in that kind of scenario, you as a joint owner of a property, you really don't want your family, your wife, your children to suffer after you have gone. So what you need to essentially make sure you do, like you said, that scenario that you painted is a scenario of joint tenancy. So what you need to make sure you do in the scenario is that whilst you are alive and all of you are alive as joint tenants, make sure that you take steps to convert that tenancy into tenancy in common, so that each person's interest is separated, and that person's separate interest can then be passed down to their beneficiaries under their will or other testamentary documents. That's essentially the key. And Ms. Adigbomire talked about essentially what you need to decide whether you want to hold property jointly with somebody. Like you said, holding a property jointly with someone like your spouse confers a great advantage, because that property automatically just moves to the surviving spouse and there's no need for probate. You avoid paying costs. But in a scenario where the co-owners are just maybe friends, it's always better to have it separated and be tenants in common, so that you can potentially pass on your own interest to your beneficiaries.
Great. Thank you, Mr. Shikoya. Okay, I have a question here for Mrs. Adegbomire. So Tommy is asking, he's saying, are there exceptions to the rule of survivorship? Mrs. Adegbomire.
So there are really no exceptions, except if you can show the court, usually it ends up in court, if you can show the court that by the language of the contract or the property agreement or the business agreement, if you can show, with businesses, it's not usually the same thing, but with property, you have to be able to show the court that the language did not intend to convey a joint ownership. So if you can show that the language did not intend to convey a joint ownership, it would help to allow the court to break up that ownership into a separate ownership as opposed. But then the question then comes, if the language also shows how much each person puts in, but often you don't see that in an agreement. So you then have to be, if they break up, even they say, okay, it's not joint, it's separate. How do you determine who owns how much? Because in a joint ownership, somebody can put in 60, another can put in 40, especially when it's husband and wife. There are cases where a wife has claimed that what she put in was her hard work. The man said, I put in all the money, but she said, yeah, you put in all the money because you had time to go to work, and I stayed at home to do all the housework, looking after the children, taking them to school, so it's not really yours alone. So yes, you can, if you can show to the court from the language usually and circumstances surrounding that agreement that it was not intended to be a joint ownership.
Great, thank you. I guess, obviously, that would be a hideous task to surmount, Yes. Thank you so much.
It's best to avoid it altogether.
So I have another question here from an anonymous attendee. He's refused to put his name. So he says, can families, business partners, avoid all of these ownership, survivorship, probate issues by using corporate entities where they are shareholders?
Okay, let me just say something, and I think Mr. Shikoya too would want to say something to that.
Yeah.
Yes. Yes, of course you can avoid it, but remember that if you decide to go into setting up a company, and I know people who do that, they set up a company and then they make all the children shareholders. There are many. One, you have to consider the tax implications of setting up a company. Two, if it is solely for the purpose of just keeping the whole family in one unit, you still have that same problem. One, you can have children born after, which you don't remember to put in the company, they're completely out of it. And if you have children who are recalcitrant, they will happily keep one child out of it. Also, because they are all shareholders, they have to make decisions together, or at least if they all have equal shares, it will be difficult when making decisions together, when you have lumped all of them into one company. I know a company now, siblings, and it's not funny, So it's not that once you have a company, it's automatic. If you have a company that all the children have equal shares, then two people can gang up. Maybe you have 4 children, each with equal shares. 2 can gang up against 2 and make things difficult to run. So it's not exactly foolproof. And I always say that there's no estate plan that is foolproof. You must plan your estate depending on your family. You have to know your people. You have to know your children, know your wife. It's not one size fits all at all for estate planning. So it's not like a company will work always. No.
Okay. Thank you, Mrs. Adegbomire. Mr. Lamide, you want to say something?
Yes, I think Mr. Adegbomire has answered the question brilliantly. I guess just to add that the truth is that, like she said, there's no foolproof approach, and the company structure can work. And in fairness, it can avoid some of the pitfalls that you have with your other usual estate planning. But I think for me, it's usually the tax implication of the company, because there is a huge tax on what on the assets of the company, essentially, at the end of the day. If you sell any of the assets as a corporate, you pay more tax than if you're going by the other way of estate planning.
Great.
Just talk about that.
Great. Thank you, Mr. Shikoya. Okay, I just want to add for our audiences, you can please look up on the chat box. The questionnaire has been dropped in there. I want to urge you to please fill in those questionnaires, kindly answer all the questions, and we'll get back to you. It's important. Okay, I have two persons who have their hands raised up here who would want to ask questions. So I'm going to unmute, starting with Mr. Ralph Akins. I'm going to unmute you to allow you to ask your questions. Please go ahead. Mr. Ralph, can you go ahead, please? Okay, I think it's finding it difficult. I'll go over to Mr. Oluwole. Kindly please go ahead and ask your questions. Mr. Oluwole. Okay, pending when we have them, let's go over to our questions and answers tab. Yes, there's a question here. It says, can the decision-making issue be mitigated? What does this say? It says, can the decision-making issue be mitigated by having share classes A, B, and C with different rights? So I guess this is speaking to tenancy in common. It says, can decision-making issue be mitigated by having share classes A, B, and C with different rights? Mr. Olamide, you want to say something?
Yes, I mean, no, the person actually asking that question in relation to the company structure that we mentioned initially.
Okay.
So yes, again, that can work, right? But the truth is that if somebody wants to be difficult, they will be difficult, irrespective of the class of shares that you have. And ultimately, you may need a court to resolve some of these issues where they eventually come up. But overall, which is the point that Mr. Adegbumire was making, that it's up to everybody to know who their family members are and then work out a structure that works based on the peculiarity of the particular family in question. If you have this kind of structure, yes, it can potentially address some of these points, but it's not cast in stone, and more so there is still that tax issue that I talked about when you are looking at the corporate structure.
Great. Thank you, Mr. Shikoya. I have another question here. So the person is saying, is this to say that there is no better way to have joint ownership organization? Is this to say that there is no better way to have joint ownership organization? Yeah, there are perks and there are pitfalls. Okay, let's have you, Mrs. Adegbumire. Are you there? And also, you could just add, I'd ask the second question too, just to tag along. Also, the person is also asking, can you recap on the tenancy in common? Same person asking this question. She wants you to provide further explanation on tenancy in common. And also, she's also asking, or rather, he's also asking, are we saying that there is no better way to have joint ownership organization?
Okay, let me talk about the joint ownership. And then because Mr. Oshiko had already talked about tenancy in common. So
yes.
He'll do the recap. So a joint, if we use the word joint ownership, there's no escaping it. When it is done and structured as a joint ownership, there's no better way. It is either a joint ownership or it is not a joint ownership. It's either a joint ownership or a tenancy in common or any other thing, but a joint ownership in the real sense of it. And remember that we don't want a better way because there are advantages to having that joint ownership we're talking about. So it is something that can be very good, but it also has disadvantages. So there's no better way. You can have joint ownership using the word loosely, which would then include things like tenancy in common. which would include things like even having a partnership agreement when you have a company, a business, you know, an enterprise, a business enterprise. You can have a partnership, and you are having a joint business, but you have a partnership agreement. The partnership agreement says who can do what and who cannot, and already establishes many things. So you wouldn't have that problem. But if it's a joint tenancy in the real sense, there's no better way. So over to Mr. Shikoya for the tenancy in common.
Okay, let me just try to explain the tenancy in common arrangement with a scenario, right? If my dad owns a 2-story building, ground floor, first floor, and second floor, and he says in his will, I give my property at number 2 ABC Limited to my sons, right? And it should be shared as follows. My son, Olamide Shikoya, should have the ground floor. My son, Patrick, should have the first floor. My son, Abidemi, should have the second floor. In that scenario, we'll be tenants in common because we have separate interest in that property. So if anything happens to any of us, that first floor or second floor or third floor, we essentially go to our beneficiaries because our interests are separate. And when people look at that property, they can say, floor 1 belongs to Lamide, floor 2 belongs to this person, and floor 3 belongs to the person. That's tenancy in common. And as distinguished from joint tenancy is that it just says, I give my property, my 2-story building at ABC Street to my sons jointly. What it means is that we are entitled to 3 of them and nobody is entitled to any of the floors. That's usually the difference. I don't know whether that person got the difference in the scenario.
Yes, I think that's very explicit, very explicit. Okay, I have another question here. The person is saying, I think this is for Mrs. Adegbomi, in a joint account now, what about if one party chooses to leave the marriage? So I assume this is between husband and wife, chooses to leave the marriage and start dragging properties she never invested in. What happens afterward? You're muted. You're muted, Mark. You're muted. Kindly unmute your mic.
I said, first of all, you said, what happens if she chooses to leave the marriage and she's dragging property that she did not invest in? Did I get you right?
Absolutely. Absolutely.
I said, first of all, let's break the bias. So when you say she did not invest, remember I told the story of investing is not only investing financially. Investing is investing with time. Investing is investing when you sit at home, you don't go to work, you don't do anything so that the other person can go to work and make money. And this has always been an issue, you know, that a housewife who sits at home and looks after the home, has she invested in anything that the man has done? It's a question that I think we all need to think about. You know, that's the first thing. So when you say she's dragging property she has not invested in, and I've been involved in things like that. The reason why she has sometimes dragged the property is because she even feels bad that I could have bought my own property. I could have gone to work. I could have made money. I chose to stay at home and be a housewife, sometimes because the husband insisted that she must stay at home and be a housewife. So instead of going out to make money and buy her own house, she stayed at home and allowed him. And then he turns around after maybe 30 years of marriage and says, you don't own anything. Why are you dragging property with me? Well, if the property is jointly in their names, she's entitled to it, they both own it. If it's a tenancy in common, then if it specifies how they own it, she owns a part of it. But if we're talking about a joint property, of course, if the property is in his name, she will have to fight for it. And we've had to fight for such things too, when it was completely in his name. If it's in his name, it's even more difficult to drag it with him. But if it's a joint ownership, oh yes, she will drag it. She will say that this thing belongs to us jointly. We both own it. It doesn't even matter how we acquired it, whether I acquired it with my sweat or with my money or with, it's a joint ownership. So she has every right to drag it. And like I said, you know, she has a right to drag it as well because she could show that, I mean, I put something into this thing. It may not have been money, it may have been other things. I knew a case of a woman who actually was on the building site, joining them to carry cement when the building was being built, her husband's building. And then he turned around and said she had no stake in it. You know, let's think about these things.
Great. Thank you, Mrs. Adigbomire. Very insightful. I have a question here, and I think this question has helped me put together the question I wanted to ask in a descriptive form. And this is from Mr. Oshikoya. Pertaining to the scenario you painted about the multi-floor building you assumed your father gave to you and your brothers. Now, the person is asking here, he says, if the father gave the property as a joint ownership, this is joint tenancy now, to the kids, no separation of who owns which floor, which legal instrument do the kids use or can they use to achieve a tenancy in common? I think in simple words, I guess this refers to partitioning. I guess. How is partitioning done, as it were? Yes.
Well, there are a number of ways to go around it. I guess the simplest and easiest way would be to do a deed of partitioning amongst all the beneficiaries. And let's go a bit more practical now. Now there's an estate, there's a will, there will be executors of that estate. One way would be to get the executors, which sometimes may be the beneficiaries and may not be, to divide that property between or amongst the children involved, so that we can agree amongst ourselves, and say that executors, please divide this property into 3 and issue a deed to each of us for each of our separate floors, so that we all can own our floor and we can all move on. There are other ways. Sometimes it may not be as easy as I've said in terms of doing this division and using a deed to do that, to achieve that purpose. And this leads me to that point I was talking about, how to determine a joint tenancy. There are other ways. You can decide to, for example, sell the assets, share the money, and each person can go and use that money to buy other properties which they will own individually. You could also, for example, say, you know what, guys, I don't want to be part of it. I want to give my share of the property to either my son or my wife or whoever. Remember, I talked about the 4 unities. And once any of those unities is missing, then it becomes a tenancy in common. So if you have to just undertake a positive act that essentially converts that joint tenancy to a tenancy in common. And once that is done, by whatever means or whatever way, then it becomes a tenancy in common, and each person who has taken that positive step can then potentially pass on that property to their own beneficiaries.
Great. Thank you so much for that. We have another question here. I think this is very key. Mrs. Adigbomire, I'd like you to speak to this. Now, the person here is saying, he says, I want to go into joint ownership, right? And assuming all the things that could go wrong will eventually crystallize, ranging from a joint owner being dubious. What's happening here? 1 second. Ranging from a joint, okay. I think that has been taken off. Okay, but I think I saw that. It says ranging from a joint owner, assuming everything crystallizes, ranging from a joint owner being dubious to death. What can be done as safeguards? What can be put in place as safeguards?
You mean if instead of going into a joint tenancy, a joint ownership, or is it that the joint ownership already exists?
No, he's planning in going into one, and he's assuming that if peradventure everything goes bad, all I've spoken about crystallizes.
knowing what he knows now, it would be better to have an agreement that allows language of a tenancy in common. Knowing what he knows now, knowing that there is an opportunity for all what we have talked about to happen, then at this point, he should be thinking of a tenancy in common rather than a joint tenancy at this point. If he has not yet gone into it, then he should be thinking of a tenancy in common rather than a joint tenancy.
Great, thank you. Thank you so much.
Having known what he knows now.
Knows now.
If he didn't know what he knows now, and he was already in it, we can think of how he can come out of it, because now that he's alive, they can have a partition. They can partition it. But as long as one party has gone, it goes straight into survivorship.
Thank you. Thank you so much, Mrs. Adigbomire, for that. Now that you know what you know now, you can be sure you have all the safeguards to put in place. Okay, Tini Yemisi wants to ask a question. I don't know if you can unmute yourself and speak. Tini Yemisi. Is that possible? Okay, so if you can't unmute, I'd like you to just please chat them, put up the questions on using the question and answers tab. Yes. Charles, can you unmute? Okay. Kindly make use of the questions and answers tab to ask your questions. Yes. Okay, I have one question here. He's saying, can we use an irrevocable power of attorney to each person to deal, however, with their respective flaws indefinitely? I'm trying to understand that. Mr. Shikoya, I don't know. With regards to that example you painted, yeah.
I'm not sure I understood the question. Can you please take it again? Let me see whether I can.
Even me, he's saying here, can we use an irrevocable power of attorney to each person to deal, however, with their respective flaws indefinitely? With regards to the two-story building given to either jointly or in common, I don't think I understand that.
I don't think I understand the question, but I suspect what the person is trying to say is whether issuing an irrevocable power of attorney to each of the joint tenants can then potentially create a tenancy in common scenario.
Okay.
I suspect that's what the question is. And if that is the question, well, it depends on what you are saying in the power of attorney, right? Ordinarily, I won't, if you come to me for legal advice, I won't suggest you go by way of power of attorney, because the power of attorney is essentially what it is. It says it gives you power to perform some acts. But strictly speaking, unless of course there are things in the agreement that suggest, in the power of attorney that suggest otherwise, then it's always better to have a positive agreement that specifically says what you want to do, as opposed to having a power of attorney just to confer powers on somebody to do so, to perform an act. So I won't advise a power of attorney if that's your question, but maybe the person can clarify the question and you can answer it better.
Yes, I think he's confirmed that what you've said is actually the question he was trying to ask, and you've already provided the answer to that. Okay, I think it's been a very exciting conversation. It's been strong learning points on joint ownership, a lot of eye-opening conversations around factors to consider before you decide to go into any form of joint ownership, and factors to also consider in planning your estate if you are jointly involved in any business or in ownership of any property. And I think it's been a worthwhile session. I'll take one last question here and we'll round up. Just again for emphasis, we have a questionnaire that has been pasted on the chat box. Kindly do well to fill in those questionnaires. It's very important. I'll take King. who is a senior associate with Meristem Trustees, to come help us round off this webinar and give our final words. Okay, here's the last question. I like this to go to Mrs. Adegbomire. She says, please, what can be done with children?
Okay, what can be done if the father has gifted an asset jointly to his children and it is causing problems? What can the children do to resolve this? Is that the question? Is that the question? Is that the question?
Yes, it is.
I'm not hearing you. Okay, yes. So what if the father has gifted an asset jointly to his children and it is causing problems? What can the children do? Well, the children will be able to do something if they are ready to cooperate. If they're ready to cooperate, then like Mr. Oshikoya had advised, they can sell the property or they can partition the property. In many cases that we've dealt with where this has happened, what has happened is that the property has been partitioned. In fact, that is what oftentimes is best. They partition the property. If it is a property that can be partitioned, that is, if it's a property, if it's 2 duplexes, for example, you can partition it and you actually do a deed of partitioning, register it in Alausa, the land registry in Lagos. In other states, they will probably have their own land registry. The best thing is to partition that property and then each person becomes an owner separately. You know, and that is what we have done in many cases. We've done a deed of partitioning, and it doesn't have to be something flat before you can partition, like 2 duplexes. You can actually partition even if you have a block of flats, maybe going up, floor 1, floor 2, floor 3, floor 4. It allows in Lagos State, because it differs from one state to the other, you can do a deed of partitioning. And so the deed of partitioning, and then it's registered with the lands registry, and each person now owns their own portion separately. So I think that's the best thing, to do a deed of partition. I think there's one question about a bank account, asking if 2 people own an account together and one dies, can the next of kin jump in? I'm not quite sure that the next of kin of one party will automatically become the owner. You know, the next of kin is for maybe if one person has died. Even this next of kin thing, usually you still have to obtain probate. So if it's a joint account and one person dies, even if the other person has a next of kin, the law of survivorship will kick in. I don't know if anybody has, I don't know if Mr. Oshikoya has any more experience on the bank account with somebody having a next of kin, but I think the survivorship law still kicks in.
Apparently, yeah.
Okay, I guess just to make a few points around this. I mean, Mr. Adegbomire is absolutely spot on. I think what I've seen from experience as well is that people who are joint tenants generally try to give out their, you know, they think they have a share of the property, of the asset, and they try to give it out under their will. I think, as we have said repeatedly, I just like to repeat it, and I think Mr. Adegbomire also touched on this point. The truth is that the rule of survivorship is such that even if you make a provision relating to that, an asset that is jointly owned in your will or another testamentary document, that provision in your will will be void to the extent of its inconsistency with the rule of survivorship. And that leads me to the point around the next of kin. Again, the next of kin issue is an issue that I usually don't even like to hear about, because the truth is that even if you name somebody as next of kin on record for an investment, for an account, most likely the relevant financial institution will still ask you to bring, to obtain probate, or, you know, go through the formal probate process irrespective of next of kin. You know, there was this recent scenario that played out where somebody had I believe it was some investment, and put the next of kin. The person actually had 2 wives, put the next of kin, put one of the wives as next of kin, and then the person's brother actually went to the probate and got a letter of administration. And the question was whether the financial institution was bound to provide the relevant investment to the executor of the or administrator of the estate, or whether to the next of kin. Of course, my advice straight away is that that should be paid to the administrator of the estate, because that's the person that has been legally empowered to administer that estate. When he then collects that money, what he does with it at the end of this is a different ball game, which the beneficiaries of the estate can sue him to account for. But for the purpose of this conversation, what's important is that the person who is entitled to administer the estate is given the right to perform their obligations, because they also have a duty to account to the courts. I think I'll just stop here because of our time.
Thank you. Thank you so much. Thank you so much, Mr. Shikoya and Mrs. Adegbomire. It's been an exciting conversation. There has been amazing learning points, and it's been an eye-opening session. I'm sure not just for me alone, but for all of our audiences. And I'm certain that all that we've learned today will give you deep thoughts in planning our estates and in making those decisions before we go into any form of joint ownership, partnership, whether it's in business or in asset acquisition. So have Mofoluwa King give us a rounding up comments as we conclude this conversation. Thank you, Folusho.
Thank you so much, Omoife. I just want to quickly speak to the points Mr. Shikoya made last as next of kin. Yes, that is very correct. Next of kin is mainly administrative, right? It doesn't confer title or interest to beneficiaries. As Meristem trustees, we have a lot of information we share with our clients and our prospects. So if you could go ahead and fill that question and provide your details. Subsequent webinars and information that we share will be sent out to you. Okay, thank you so much everyone for joining. Thank you for the privilege to educate you today. We are Meristem trustees, and we are always available to provide educative information to you. We want to especially thank our panelists in the person of Mr. Olamide Oshikoya and Mrs. Shola Adegbomire. Thank you so much. I know I hassled you a lot throughout this process, and I thank you for sharing from the wealth of your knowledge. We really appreciate it. Thank you for all the attendees taking out of your very busy schedule today to attend. We trust that this has been very educative and informative to you. If you have any additional questions whatsoever, please do not hesitate to reach out to us at trustees@meristemng.com. You can also follow us on all our social media platforms: Facebook, YouTube, Twitter, Instagram. Meristem NG is there for you, and we are available to answer all your questions. Thank you for the audience for your questions. Your questions show that you got insight. Your questions showed insight into understanding into the topic that we discussed, and we are available to share very many more educative sessions like this with you. Thank you all for your time. We hope to see you again very soon at our next webinar, which we'll be hosting hopefully anytime soon. And thank you, panelists. I'm sure that next time we call upon you, you won't say we troubled you too much. You are available to also help us in sharing your wealth of knowledge. Thank you also very much. Do have the rest of your, I wish you a very productive rest of the day. And thank you. Thank you all.
Thank you very much. Thanks for inviting me. Thanks for inviting us.
Thank you. Thank you.
We hope to see you.
Thank you very much.
Thank you. Thank you. Thank you.
The beauty of wealth lies in growth.
You've reached the stars. Now let's see you conquer galaxies.
The beauty of wealth lies in growing, preserving, and transferring it. Building wealth isn't only what you do for yourself, it's what you do for generations to come. And to pull that off, you need partners. Partners who understand that the assignment isn't just to grow your wealth, but to preserve it. Against the harsh storms of life, and ensure it sees the light of day, ready to be transferred from generation to generation. So you see, the art of building wealth is all about growth, preservation, and transfer. And at Meristem, we have perfected that art.
Meristem. Let's grow wealth for you.
You've reached the stars. Now let's see you conquer galaxies.
The beauty of wealth lies in growing, preserving, and transferring it. Building wealth isn't only what you do for yourself, it's what you do for generations to come. And to pull that off, you need partners. Partners who understand that the assignment isn't just to grow your wealth, but to preserve